Well, 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 it seems bump stocks are back on the menu following a Sixth Circuit Court of Appeals ruling that bump stocks are not actually machine guns. Now, I know people are going to have varying degrees of familiarity with the mechanical plus the legal realities going on here. I'm going to walk you through both as best as I can. I'm Nick Ricada of Ricada Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that stuff, hit the subscribe button, hit that notification bell. Don't miss any videos, okay? We're going to go back to 2017, and then I'm going to carry you through yesterday, March 25th, when the Sixth Circuit made their ruling, and tell you why this all happened in the way it did and what it is going to do going forward and how this all works out, okay? So watch through to the end of the video to get all of the information about this. First, what's a bump stock? A bump stock is an attachment to a semi-automatic rifle that uses the mechanical force caused by basically the recoil from the bullet ejecting from the chamber and all of that built up gas pressure, pushing it back against the stock, which then pushes the receiver back forward. That's a pretty simple thing. It's basically a spring. if you want to put it that way, it's a spring that sits between the receiver and the stock. And then what that causes to happen, however, is when you pull the trigger on your semi-automatic rifle, that back and forth action activates the trigger over and over again. As long as you keep your finger in place, the trigger will activate without you having to physically pull back on your finger multiple times. So a semi-automatic weapon is able to fire very, very rapidly with a bump stock because it's using the physical action of the gun itself to activate the trigger again. And that happens typically much faster than our muscles are able to contract and pull that finger back against the trigger. So that being said, it makes a semi-automatic weapon fire in a manner similar to an automatic weapon. However, we've got to get into the rule here. So that's what a bump stock is. The rule says that a machine gun, which are classified differently than a semi-automatic weapon, they require special licensures, special taxes, and they're generally less available. Also, machine guns cannot be manufactured after 1986, which is another issue with all of this. But because of all of that, it made bump stocks, it makes the machine gun industry a very, very difficult industry for a civilian to actually engage in. And it lowers the overall availability on the market and all sorts of stuff like that, okay? So that's what the rule accomplishes. The bump stock is the actual thing. The rule about machine guns sets up a different classification of firearm that is more heavily regulated and therefore less available in the market to the general public. So what the rule says for a machine gun is a gun which fires more than one bullet on a single pull of the trigger. So that's the rule. None of that has changed. There's been no congressional reclassification of machine guns or anything like that. But back in 2018, following the mass shooting in 2017 in Las Vegas, you know, the one that no one really likes to talk about because it wasn't the best political narrative for the news story. So they kind of were like, whoa, we'll forget that one kind of happened. Anyway, following that 2017 mass shooting, and then in 2018, the ATF under Donald Trump, that's the Bureau of Alcohol, Tobacco, and Firearms, under Donald Trump, reinterpreted the rule. Again, without the legislature, they can't change the wording of the law, so they reinterpreted it. They read it a different way. Remember that language I said, the single pull of the trigger. They read that rule to mean a single pull by a finger of the trigger. So they included what they're calling the human element. So a human is only pulling back one time on the trigger, and therefore they're saying that that is a single pull, and because of the mechanical action of the bump stock, it was firing multiple rounds. Therefore, they classified a bump stock as a machine gun. People who know about guns, people who know about bump stocks and understand how they work all went, but it's not a machine gun. It's not even close to a machine gun. There's all sorts of various criticisms and discussions about bump stocks and their usefulness and all of that. I'm not going to get into that. I don't own a bump stock, so it doesn't really matter to me on that level. And I'm not going to pretend to be an expert on it other than just knowing the basic mechanics behind how it functions. Okay. So everybody, when this ruling from the ATF actually came out, originally, everybody who knows about this is confused because they're like, but that's not a machine gun. That's an attachment to a semi-automatic weapon. It doesn't change the internal mechanics of the weapon. And the trigger itself is actually actuated one time every time a bullet is fired. Now, granted, the finger that you pull remains in the same position. The ATF is right. You basically pull one time. However, the mechanical action of the gun presses the trigger back against your finger, causing the trigger to activate and unactivate, just like that, just really quickly, much quicker than we're capable of doing. So it gives the illusion of automatic fire, but it's not actually automatic. The gun itself is using the mechanics to work. So people were very confused about this. They filed a lawsuit and they asked for an injunction and they said, no, you can't call a bump stock a machine gun. It's not a machine gun. You don't get to do that. And we want an injunction on this ban so that bump stocks are still available while we figure this out. The court said no injunction. And then they similarly said, nope, we're going to defer to the ATF under something called Chevron deference. This goes back to a case that involves Chevron Oil Company and some environmental regulations. And basically, it redid how administrative law works. It is the most cited case in administrative law right now, and it's a mess. But basically, what it says is that a regulatory agency has the ability to interpret the rules within the laws and purview of the agency. Now, again, this is under environmental law, so this would be like the EPA interpreting laws about clean air and clean water, and then the courts giving deference. Under the Chevron case, they would give deference to the regulatory agency to interpret the laws that it's implementing. So in this case, they're saying the court said, well, we need to give deference to the ATF about the law that it's interpreting here. And therefore, under that deference, we're going to give them the benefit of the doubt and say that they're right on their interpretation of the law. And that's where the ruling came out, I believe in 2019, denying the injunction and saying, nope, we're going to go with the ATF's language on this. And bump stocks were officially and fully banned by the district, or, confirmed by the district court. They had already been banned by the ATF. There was no injunction on it. So it went into effect immediately. But the court affirmed that and said, yep, this thing is banned. Well, that got appealed because, again, anybody who understands how this works and can read the law says, but it's not a machine gun, though. If you want to ban these, you got to go through Congress to do it. The Sixth Circuit Court of Appeals up in Michigan took a look at it and they said, yeah, that's right. This is not a machine gun. This is not a machine gun. And part of the way they did it is to deny the Chevron deference in this case. And the reason they denied it in this case, while it is so often cited and upheld in other cases, is that they drew a distinction between civil penalties and criminal penalties. In Chevron deference, they're talking about applying, the Sixth Circuit says that they apply Chevron deference in cases that involve civil penalties. However, when a case implicates criminal law specifically, that is making bump stocks illegal, fining people who don't, fining people or even putting them in jail for engaged in the trade of these things or the possession of these things. Because remember, this bump stock under the ATF's rule, just the bump stock itself, owning one is the same as owning a fully automatic machine gun. So you would have to have the same license requirements. You would have to have the same tax implications that would come with owning that machine gun. Just having it, not using it, not taking it out in public, having it in your house suddenly became potentially illegal for millions of people. So that being said, the Sixth Circuit Court says, wait a minute, no, Chevron deference doesn't apply when we're talking about criminal statutes, because part of our protection, the presumption of innocence and all of that stuff that's built into the Constitution from the government intruding on us says, okay, wait a minute. These criminal protections require a higher level of I guess, review, and the public, the general public has the, how did they word this? Basically, they have the moral responsibility to determine what is illegal and merits criminal punishment versus, just sort of civil disputes between two parties. So that's the big difference that they're focusing on in the Sixth Circuit Court. Now, what that means, however, is that they said, okay, there's no Chevron deference here. So we don't look to the ATF. We don't look to the ATF's interpretation of the rule. We're going to look at the rule, and we're going to look at a bump stock, and we're going to see if a bump stock matches the rule. And so they looked at the plain language of the rule, which says a single pull of the trigger. And they said, okay, does a bump stock fire more than one round with a single pull of the trigger? No. As that's the only conclusion you can possibly come to in reading that text. The trigger itself is pulled every single time a round is ejected. So one pull of the trigger, one round is ejected. That's it. There's no two ways about it. It's the only way that it operates. In fact, if somehow the bump stock malfunctioned or the spring broke or whatever, and the gun wasn't able to push back and actuate the trigger again, another bullet would never leave the chamber. The trigger would just remain pulled. So, the court rules, nope, this is not a machine gun. Under the language of the actual statute, it can't be a machine gun because there is only one bullet ejected each time a trigger is pulled, and the trigger has to be pulled a second time for a second bullet to come out. And that's that. That's the answer. So then the more important thing that they did was they said, since there is no Chevron deference and the court's decision is binding on the lower court here, they said, we're going to remand this case back to be reheard with our guidance, which basically says you're wrong and the law does not say that these are bump stocks, and so you have to rule according to that. They also have said that you need to issue the preliminary injunction. You need to issue that injunction because now that we've taken away Chevron deference from this case, you have to look at this and say that the plaintiffs are likely to succeed on the merits. Since they're likely to succeed on the merits and there's immediate harm, the preliminary injunction needs to go into place. Now, all of that unscrambled means that this is going to go back to the lower court. The lower court will have to undo its upholding the ban on bump stocks, and they will have to enjoin the federal government, which means to prevent the federal government from banning bump stocks. So they're overturning the ATF's interpretation and saying, nope, bump stocks are not banned under this interpretation. Therefore, bump stocks are legal again. And that's what has to happen. So this is an interesting case because since there was no law that changed or anything like that, it should just revert back, and bump stocks should be back in action very quickly. As soon as the lower court goes ahead and actually issues that preliminary injunction and then issues its decision, finding that bump stocks are not machine guns, according to the Sixth Circuit's guidance, then the only option would be for the ATF to take it to the Supreme Court. And that'll be pretty interesting to see what happens there. With Joe Biden's administration, I imagine we will see a Supreme Court challenge to this. It'll be curious to see what would happen because the Supreme Court has been hesitant. They have been hesitant to pick up any Second Amendment related cases. And the bump stock ban itself has potential to implicate other Second Amendment issues, specifically regarding the National Firearms Act and how the ATF actually interprets these laws, what authority any of this stuff has. And so if the Biden administration pushes this into the Supreme Court and the Supreme Court takes it, we could see a ruling with some maybe less intended consequences going on. And that is pretty interesting to me. I don't know, though. What do you guys think? Drop a comment down below and let me know. I would love to hear your thoughts on this. Do you like bump stocks? Do you hate bump stocks? What do you think about the Second Amendment and our right to carry? Personally, I think, bump stocks are clearly protected under the Second Amendment. I think that, I think semi-automatic weapons are protected under the Second Amendment. I think fully automatic weapons should be protected by the Second Amendment, and I actually find the National Firearms Act to be wholly unconstitutional, but that's me. I'm old-fashioned that way. But like I said, tell me what you think down below. I would love to hear from you. Hope you found this video informative, and I hope you found this news uplifting. Have a good day. Peace. Peace.